Welcome to Influential Entrepreneurs, bringing you interviews with elite business leaders and experts, sharing tips and strategies for elevating your business to the next level. Here's your host, Mike Saunders.
Hello and welcome to this episode of Influential Entrepreneurs. This is Mike Saunders, the Authority Positioning Coach. Today we have with us Rick Martin, who's the owner and founder of Martin IP Law Group. Rick, welcome to the program.
Thanks, Mike. Good to be here.
Yeah, I'm excited to talk to you because I know that intellectual property and branding and trademarks is a pretty vast topic that many entrepreneurs don't really think about. They think, oh, let me just say this, do this, use that, or they don't think to protect themselves. So if we can talk through some of those things entrepreneurs can be aware of, that would be awesome. And before we get into that, give us a little bit of your background. What is your entrepreneurial journey? Because yes, you're an attorney, but as an entrepreneur, you have to, kind of coexist as a, thought leader, entrepreneur, as well as building your business.
Right. Thanks, Mike. And probably the best place to start my entrepreneurial journey would have been maybe about 20 years ago. I had actually spent 5 or 6 years working for some large law firms in Texas. And without going into too much detail, I'll just say that working for the big law firms just wasn't really my thing, and didn't have a good experience with it, and really wanted something that was a little more that I had a little more control over, the work that I did, how I did it, and a little more control over my life. So that's when I basically moved, back home to Indiana, where I grew up, and that's where I am now, and started my own practice. So at that point, and it's grown since that time, and kind of changed directions a few times, but here we are today, and we're back to focusing on just intellectual property issues and advising clients on those patent, trademark, and copyrights that they need to grow their businesses.
Yeah, and I think that a lot of people, assume that they know, I read that article or I Googled this, and typically that's not enough. So you're working on a book specifically about trademark and IP for entrepreneurs. So tell us a little bit about that project.
Yeah, Mike, the book is 7 Things Every Entrepreneur Should Know About Intellectual Property, and it covers I wouldn't say it covers everything, but it probably just hits the highlights and covers a lot of things maybe that entrepreneurs don't think about when they're starting up a business. And, it covers both sort of, I'd say, the offensive and defensive side of IP, just to give everybody an overview of what they need to be looking for.
So, you say offensive and defensive. So give us an example of each. Think that a lot of people might think it's really broad, but there's 2 ends of the spectrum, right? Offense and defense.
Well, yeah. The one end of the spectrum, which I guess I would say would be offense, is protecting your IP. Recognizing, identifying what intellectual property you've developed, and then proactively protecting that IP. So whether that be through patents, trademarks, copyrights, or trade secrets, one, you've got to identify, and again, it helps to work with an attorney or somebody that's experienced in, both identifying and protecting intellectual property assets. But that's the first step, at least on the offensive side. Identify it. Second step would be to protect it. On the defensive side, again, it's you need to be aware of other people's IP, and kind of make sure that you're not stepping on their toes, so to speak. Really, patents, for example, what a patent does is, in some sense, it doesn't even allow you to practice your own invention. What a patent does is it allows you to exclude everyone else from practicing the patented invention. So if somebody else has something patented, you need to be aware of that. So if there are other players in that field out there, other competitors, it's a good idea to keep an eye on what they're doing, what they're patenting, and get some advice on what you can do or what you need to do to avoid infringing their rights.
And is there an element of if you've taken the offensive, I think, and you've started trademarking and patenting some of your concepts, your intellectual property. How do you make sure that other people are not infringing on that? What are some tactical things to make, because your head's down doing your business. How do you know if someone is starting to take liberties they should not, and then you need to decide what action to take there?
Well, and some of that is going to present itself to you. I mean, obviously, if you've got a product and you're selling the product, and you've got salespeople that are out there, promoting this product, if you've got competitors that are trying to step on your patent rights and sell the same product or a similar product that's covered by your patent to your customers or to other people out there, it's probably going to present itself to you in that way. With regard to trademarks, again, similar. But there are also some watch services, and again, we have some of those that we use here at Martin IP Law Group, where we keep an eye out for trademarks primarily on the watch service, because it's a little easier to set something up like that, where we keep an eye out for our clients' marks to make sure that other people aren't using similar marks and infringing their rights. And if we come across something, we alert the client to it. If it's something that's an issue, then we can send a cease and desist letter out and address it from there.
Yeah. So in your book, you mentioned 7 points entrepreneurs should be aware of. Let's talk through a few of those and what are some of the things to be aware of.
Okay, I'll run down maybe the seven that I feel are important here real quick. So one, just again, I think I touched on it earlier. Your intellectual property is a valuable asset, and you need to protect it. So that would be number one. Number two is identifying your IP, whether it be patents, trademarks, copyright, or trade secrets. Third thing, and again, I see this all too often, is you need to secure your IP protection before you disclose your particularly in the area of patents. Before you disclose your idea to someone else, you need to secure that patent protection, or at least an application on file and have patent pending status. Fourth thing is just to consider who owns the intellectual property, and it's not always necessarily the person that creates it. So that's an issue I think that needs to be looked at. 5, I encourage at least all clients in this day and age to think globally when they're looking at IP protection. The world is becoming a smaller place every day, and a patent strategy or trademark strategy that looks ahead and addresses that is probably one of the best ones. 6, and I think we discussed this earlier, be aware of the IP of others. Keep a defensive strategy. And then number 7 is, I suggest that every entrepreneur really develop and implement a comprehensive IP strategy and follow through with that.
A couple of those jump out at me. Number one is I like the point that IP is an asset that needs protection. So, I think when people think of the word asset, they think of, like stocks, bonds, mutual funds, your house. Those are assets that can grow in value. Mm-hmm. Can IP grow in value?
Oh, absolutely. Yeah. It's, again, it's sort of the law of supply and demand would dictate that to some degree. I mean, it's, a patent, for example, gives you basically a 20-year monopoly on that patented invention. So if there's a demand for that product and you have, basically the ability to exclude everyone else from making it unless they license it from you or get your permission, then, that asset, that patent increases in value based on the demand for the product that it covers. Trademarks, for example, are another good example too. I mean, the brand awareness, the branding, I mean, the Nike swoosh, the golden arches, those obviously have value because they're recognized symbols that everybody knows and associates with the products or services of that company.
And I think that just like when Amazon, who we know today as Amazon, when they started and picked the name Amazon, people just thought it was a river in some faraway land. Well, today we know Amazon is, the big behemoth that it is. So the point is, you don't know today what your IP can be down the road. So hence your need to protect. So I think that's a really big point. And then growing in value and maybe feeding that to help it to grow in value. So you said something else that I thought was really curious. How can someone that creates intellectual property not kind of, own it? You said sometimes, someone that doesn't even own the IP, even though they created it.
Well, and I'll maybe look at three different areas: patents, trademarks, and copyrights. So let's start with trademarks. So trademark is essentially owned by, I'd say it's usually a company, but the purpose of a trademark is to identify the source of a particular product or service. So it's almost always, McDonald's Corporation, owns the rights to the trademarks there, not an individual. So that's the person that owns that. Patents, you get into a situation with patents where, I guess by default, the inventor of the patent owns the rights. However, in a lot of situations where the inventor may be employed with a company, there's most oftentimes companies are going to have employment agreements with these engineers that work for them that range. I've seen some that are specific that even go so far as to say, if you invent something in your garage at home, we own it.
Oh wow!
The more normal situation is if we're employing you as an engineer and you're working here for our company and you develop something in the scope of your employment that relates to what we do, then we own it. And like, again, the contract is going to govern that. Mm-hmm. And copyright is somewhat of a similar animal to whoever creates the creative work, whether it's music, whether it's a sculpture, a painting. The artist owns or the artist, author, whatever, owns the copyright unless it's considered what's called a work for hire. So Mike, if I hire you, let's say, to paint a mural for me, and I pay you X number of dollars to do it, generally, I am going to own the copyright in that because, I hired you to do it. It's going to be in most cases considered a work for hire under that scenario.
But shouldn't there be some type of document that transfers that? Because there could be the artist that kind of knows that and the person that buys it doesn't really know that. And then if that painting becomes of value, the artist is the one that, never provided a piece of documentation. Well, has that ever come up, or is that a thing?
Oh, yeah, I'm sure that comes up all the time, and that's why we have courts to resolve those matters. And again, there a lot of times in the law there are no bright lines. You can help make the lines a lot brighter by reducing everything to writing. So yeah, I certainly recommend in every situation like that that it be spelled out in writing up front who owns it, and that's always the best practice.
Yep. And thinking about, when you're an engineer working for a company, I know a lot of universities will go out and seek out thought leaders to come on board to whether it's a think tank or project or something like that. I'm certain that both parties should make sure that there's documentation in place, because you think of these scientists that work for universities and they come up with something, a proprietary process, or even get some patents up under there. I would suspect that that's something that's pretty big, because you hear on out in the world, university studies prove XYZ. Well, someone has to come up with that concept. So does that kind of get hairy where there's employment agreements and someone like a scientist is the one that came up with this, but yet they work for a company or a school? Yeah,
I mean, that could get, again, and that's, sometimes the courts have to untangle those messes that people get themselves into, because it's entirely possible that someone that, could be working for a company and have a written obligation to assign inventions to the company, and then engage in some, university research with a written obligation to assign, rights to the university. So, you get into conflicting interests there, and, again, every situation is different. It's going to depend on the particular facts of that situation, and what the documents say with regard to who owns what.
So thinking about an entrepreneur, and maybe not necessarily pure startup, but they're in business 3 to 5 years. They're getting the ball rolling, and they don't have dozens of employees. They don't have millions of dollars in revenue. But I'm sure there's cases where those, on the lower end still need to think about trademarking and intellectual property. What would some of the cases be there to be aware of?
Not 100% sure I follow the question there, but it's really a lot of the same factors. I don't think it doesn't really matter too much whether you're a big company or a small company. I think it's important just to kind of keep your eye on the ball here and make sure that. And again, I think
but do you need to worry about logo? Protecting a logo, or protecting a name of a product line, or things like that.
Okay. I think it's a good idea too. So if we're talking specifically about trademarks here, I think that's probably a good idea, and I'll give you maybe some sort of general examples here. Again, it's always a good idea to vet the names that for your products, for your business, for your services, whatever, before you start using them. I can recall a couple of examples where I've represented. I've had clients come to me in a situation where they started up a business, and they were exactly in the shoes you're talking about. They've didn't have millions of dollars, didn't have a big business built up, but they had spent 3, 4, 5 years building their business, growing, getting some brand awareness and recognition for their name. So they spent 3, 4, 5 years building this brand recognition, only to get a cease and desist letter from somebody else that had filed and been granted a U.S. trademark for the same or very similar name. So, there's 3 to 5 years of investment kind of just thrown away, because now, they're looking at, okay, do we fight this, which is probably going to be a losing battle, or do we rebrand? Do we have to change our name? So, it's a good idea really to look at those things early rather than later. And I encourage people to look at this really as an investment in your business, not an expense that you're paying, me or some other attorney to kind of vet these names for you and register these names for you. The benefit of registering the name is you're reserving the name. If you register and are granted a U.S. trademark on your name or your logo, then that extends to all 50 states. So typically with a trademark, if you're operating under common law without having it registered, your rights only extend to the geographic area that you're working in. So, if I start a business under XYZ, name here in Indiana, and I don't register it, that wouldn't prohibit somebody, say, in California from adopting the same name for the same business and operating under it there. And that happens a lot. Again, that situation that I mentioned with clients that have come to me, that's how those situations happen. And then as both businesses start to grow and they grow into each other, that's when problems arise. So it's always best to one, check and make sure somebody else doesn't already have it registered, and if not, register it yourself.
And that means you need to be aware. You need to think a little ahead and not be reacting once something has happened. So kind of taking that proactive action and being offensive on the offense, like you mentioned previously. So, Rick, thanks for coming on today. What's the best way people can reach out, connect with you, learn more about some of your packages, and also pick up a copy of your book when it comes out?
Probably the best way is through our website, which is ipsolutionslaw.com, or email me direct, and that's rick@ipsolutionslaw.com. Probably the two best ways to reach us. And yeah, we do have some packages on there. One I'll just mention very briefly, it's point 7 of my book is develop and implement a comprehensive IP strategy. And we have some what I'll refer to as flat rate plans where we essentially act as your part-time in-house IP counsel for a flat monthly fee. And so we're there being proactive with you rather than reactive in developing this strategy and implementing this strategy for all IP.
Love it. Thank you so much, Rick. I'll make sure that we have the link directly to your website in the show notes, and I really appreciate your time coming on today.
All right. Thanks for having me, Mike. I appreciate it.
You've been listening to Influential Entrepreneurs with Mike Saunders. To learn more about the resources mentioned on today's show or listen to past episodes, visit www.influentialentrepreneursradio.com.